Howdy, my name's Brian Foley. I'm a criminal defense attorney and I'm the managing partner at Houston Criminal Defense Attorneys PLLC. Today we're continuing the Texas Penal Code sections. Today's section is going to be 3.01. Now, we had done a brief overview of chapters 1 and 2 because there's not a whole lot going on in those chapters really. They're pretty straightforward and we don't reference them a lot. And they're pretty easily understood. Chapter 3 starts getting a little more technical, and 3.01 talks about multiple prosecutions. So let's take a look at it. It defines something called a criminal episode, and that's important because the rules for how you can be sentenced and if the prosecution can join two different cases together and try them to the jury at the same time, those all changed based on whether or not something's in a criminal episode. So the definition here in this chapter, criminal episode, means the commission of two or more offenses, regardless of whether the harm is directed toward or inflicted upon more than one person or item of property under the following circumstances, okay? Two different circumstances. One, the offenses are committed pursuant to the same transaction or pursuant to two or more transactions that are connected or constitute a common scheme or plan. Or number two, the offenses are the repeated commission of the same or similar offenses. So think about robberies, let's say. If you commit 3 robberies in a row, okay, same night, that is one criminal episode, okay? Multiple transactions, if they're all at different locations, but one criminal episode. The second prong there, the offenses are repeated commission of the same or similar offenses. Let's say it's a robbery, but it's not the same day, not a few hours apart. It's once a week. Repeated commissions of robberies, that's going to be repeated commission of the same or similar offenses. So then let's go on to 3.02, consolidation and joinder of prosecutions. A defendant may be prosecuted in a single criminal action for all offenses arising out of the same criminal episode. Okay, so that is when you join the cases together as a prosecutor. You can join them together if they were one after the other, or, like we say, repeated robberies or something like that. It's normally robbery. That's what they normally do. There's almost no other crime that gets joined like that. Maybe a murder and a robbery or something like that. But if you've got a couple thefts from Walmart, they're just going to do it under aggregate theft statute, which enhances your punishment range. And you can stretch them out over a longer period of time. This chapter 3, joinder and things like that, it's normally for, those offenses like robbery, really. Every now and then child sexual assault, but in child sex assault cases, they often just charge a single incident, and then they can actually get in under the rules of evidence. They don't have to join multiple transactions together. They can just get into talking about multiple different instances based on even conformity for character. Anyway, that gets into a lot of evidence stuff. Check out our evidence blogs if you need more information about that. That would be the rules about getting into priors under 404B, and then the sections in the Code of Criminal Procedure we're going to get to later in that series. Okay. When a single criminal action is based on more than one charging instrument within the jurisdiction of the trial court, the state shall file written notice of the action not less than 30 days prior to trial. So the state has to give you this 30-day notice in order for them to join the cases together and try them at once, okay? And then look at this subsection C. If a judgment of guilt is reversed, set aside, or vacated in a new trial order, the state may not prosecute in a single criminal action in a new trial any offense that was not joined in the former prosecution unless evidence to establish probable guilt for that offense was not known to the appropriate prosecuting official at the time of the first prosecution commenced. So if you're going to join stuff together, you better join everything, or if it gets reversed and you lose on appeal, you can't come back. I think that maybe would be malicious prosecution if they try to do that. Okay, let's look at section 3.03, sentences for offenses arising out of the same criminal episode. So we call this the stacking provision of the penal code. 3.03 allows the government to stack sentences on top of each other. So almost all the time, your sentences are going to run concurrently, which means they run at the same time. And this statute says when they can run consecutively, meaning one after the other, which bad news for if you're a criminal defendant. You don't want them to run consecutively. Well, you don't want any at all, but if you're going to get one, you want them to run concurrently. So here's what it says. When the accused is found guilty of more than one offense arising out of the same criminal episode, prosecuted in a single criminal action, a sentence for each offense for which he has been found guilty shall be pronounced, except as provided by subsection B, all the ways to stack the sentences shall run concurrently. So if it's the same criminal episode, the sentences are going to run concurrently, unless, okay, here we have the different exceptions. An offense under section 4907 and 4908, 4907 is intoxication manslaughter, is intoxication assault, 4908 is intoxication manslaughter. So either one of those, regardless of whether you're accused of violations of the same section more than once or is convicted of violations under both sections. So let's say you're driving your car and you've got your best friend and they're, a couple acquaintances that you met at a bar. The worst happens, you get in a car wreck and all three are injured, right? The reason you get in a wreck is because you're intoxicated. Well, the state could charge you under 4907 and stack the sentences, even though that all happened in the same criminal episode. So you could get up to 10 years in prison on each count. So it'd be, 1, 2, 3 potential victims there. That would be up to 30 years if the prosecutors wanted to stack the case. If they charge it as a deadly weapon used, the car being a deadly weapon, then you could end up having to serve half the time. So really big information here in section 3.03. Let's see. The next one is if you get prosecuted under section 33.021, which is online solicitation of a minor, or the following list of sections, okay? And that is 21.02, which is continuous sexual assault of a child, 21.11, indecency with a child, 21.011, sexual assault, 21.021, aggravated sexual assault, okay? And 2502, which is prohibited sexual conduct, and 43.25, which is sexual performance by a child. So all of those are things that you can stack under subsection 2 here. B2 says, under those various statutes, if the offense is committed against a victim younger than 17 at the time of the commission of the offense, and that means they could stack it. They could stack the sentences for any one of those different offenses. Okay. Then we've got section 21.15, which is invasive visual recording. Okay, so this is like spying on somebody in the bathroom area or something like that. Then we have the next one is possession or promotion of child pornography. Those can all be stacked. Trafficking of persons, continuous trafficking of persons, compelling prostitution, injury to a child or elderly individual if it causes serious bodily injury, those can be stacked. And that's, a laundry list there in section 3.03. Then finally in 3.04, it lists the right to be able to sever. So 3.04 is severance, and it says whenever two or more of these offenses that are listed in 3.03 have been consolidated or joined for trial under section 3.02, the defendant shall have the right to severance of the offenses. In the event of severance under this section, the provisions of section 3.03 do not apply, and the court in its discretion may order the sentences to run either concurrently or consecutively. Okay, so let's say you have robberies, okay? Now we looked at the times where the state could ask for the sentences to be stacked under 3.03. Well, robbery wasn't listed, okay? If it's just, 3 robberies same night, the DA tries to join the charges together, you as a criminal defendant have the right to object and not join those offenses together. You can sever them. You have this absolute right to severance, but there's a consequence there. The provisions don't apply And it says, in the event of severance under this section, the provisions of 3.03 do not apply. The court, in its discretion, may order the sentences to run concurrently or consecutively. If you don't move for severance, it is required that the sentences run concurrently at the same time. If you do have the severance, then it's up to the judge. They could run them either way. The right to severance under this section does not apply to a prosecution for an offense described by section 3.03b unless the court determines the defendant or the state would be unfairly prejudiced by a joinder of offenses, in which event the judge may order the offenses to be tried separately or may order other relief as justice requires. So that means the right of severance doesn't apply if it's one of those offenses we just looked at in the laundry list, mostly child sex offenses, things related to that, or we've got the intoxication assault, intoxication manslaughter statutes. They do have that one for injury to a child, but that is only if it is punishable as a felony of the first degree, regardless of whether the accused is convicted of violations of the same section more than once or is convicted of violations of more than one section. So it has to be first degree. And that's chapter 3. Thanks for tuning in.